Everybody else excited? Woo! I'm excited. 2020, great year, great new decade. So this is a presentation being presented by Law to the People. This course has been approved for 1.5 journal CLE hours. At the conclusion of the course, we report this time that you spent with us to the North Carolina Bar for all of our North Carolina licensed attorneys. If you are a certified paralegal or licensed in the state other than North Carolina, a certificate of attendance can be provided to you. So let us know if you need that certificate. Now, I do want to mention, for purposes of CLE reporting, that taking the course today on January 7th is appropriate for CLE compliance for 2019 or 2020 because you have until February 29th to take courses. I would like to say, though, that during this season, we report your hours very, very quickly to the state bar. There is sometimes a delay in when they actually update your records because you can imagine a lot of attorneys are taking courses this time of the year. And so that delay is not anyone's, it's not an error, it's just life. But when your hours are updated on the bar's website, they will reflect January 7th being the date you took the course. So this shouldn't be an issue for you guys, but it's like an announcement we make. Usually it's really more important towards the end of February. But for you guys, you should literally see your hours before the end of February. But if you were taking, let's say you took a course like February 28th and deadline's February 29th, well, you're not going to see that on your report until March. Well, March is past the deadline, but you took the course in the appropriate time period, so you're still in compliance. So we like to clarify that for people. Sometimes it creates anxiety, and I don't want you to have that because you are doing what you need to do in order to get your hours in. So we'll get started with a live presentation. I do have an initial poll, just curious about who's out here with us today. And this is one of the ways you can interact with us. And so I believe I launched this poll. Yes. Let me make sure. Yes, I have. Great. And so if you could go ahead and answer those questions that are on your screen there, or that one question, that would be great. You can also use the chat button if you have comments or questions, or the raise your hand button if you would like to get muted. Those are all ways that you can interact. And so we'll give you guys a moment to answer this. You know, one of my missions is to encourage attorneys who are engaging in non-traditional practice. Have other jobs and other careers, but to do things that may not do things that help people in the community who need legal services, but may not necessarily require you to go to court. And this is actually one of those areas. And so I just want to encourage those of you who don't practice in personal injury that it may be because you have another job, which is great. You have that income and you're fulfilling your passion. But you can still help someone who is in need of assistance with the right tools. We have a series of courses on personal injury. This is one we pulled out for purpose of today, and it looks like 75% of you guys actually do participate in this area of law, which is great. And for those of you who don't, this is something to think about. So case law updates, what is that all about? Basically, we take cases that were decided by the Court of Appeals and or the North Carolina Supreme Court. It's usually the Court of Appeals, though, because they take on most of these cases on appeal, and we analyze them for purposes of figuring out good trial strategy. So it's an appellate review, but it's actually designed for the trial lawyer. Sorry. So that's kind of the goal. It is actually for the practitioner, but it's just a way to develop good strategy. So one of the caveats I have to say, and I would usually say this in all of our PI stuff, is that many personal injury cases come down to procedure. Now, that's not the fun stuff you see on TV, but it is extraordinarily important. Um, a lot of times the injury is simply not debatable. A lot of times someone, and you actually see as a finding of fact, there might even be a stipulation that the defendant stipulates that they were negligent. And you're thinking, when that case comes in your door, wow, this is the slam dunk. The defendant literally stipulated that they were negligent, which is great. But then the defense bar has become very good at raising issues of procedure. So, as the plaintiff's bar, which is where my vantage point, we need to become even better at preparing ourselves to deal with procedural issues. So, I say that because I want you to know that going in, a lot of our cases will discuss procedure, but that is not an accident. That is actually where a lot of cases end up getting dismissed. So this first case is a perfect example of that. You've got a voluntary dismissal, a statute of limitations issue, a res judicata issue, all in one. And so you almost could discuss this whole case without even knowing what happened as far as the injuries, because that wasn't the debatable issue. So we'll start off with picturing our state of North Carolina and thinking about the bordering states, Tennessee being one. They have a 1-year statute of limitation for personal injury. That's important for our fact pattern. The accident happened in North Carolina, but the residents were residents of Tennessee. If you're in that part of the state, you often go back and forth between the border, right? So the case was initially filed in Tennessee. Within that 1-year statute of limitation that Tennessee has, which, to us is crazy. Then the plaintiff took a voluntary dismissal, same concept as we do in North Carolina. So then the plaintiff refiled the case in North Carolina. Past the 1 year for the Tennessee statute of limitations, and past the 1-year extended statute of limitation for refiling in Tennessee. Okay. In other words, if he wanted to refile his case in Tennessee, he couldn't, but he refiled it in North Carolina. He filed it in North Carolina. So the question is the case barred in North Carolina because this was voluntarily dismissed in Tennessee, and it was filed outside of the Tennessee statute of limitations? So let's see if I can get this poll question up. This is it. All right. So we like to get your thoughts on that. To engage with you guys. What do you think? Do you think that this is appropriate? Give you guys a moment to answer that question, just gauging your thought on that. So again, Tennessee 1-year SOL, you can voluntarily dismiss in Tennessee just like in North Carolina, refile within a year. But now we're well within 2 years since the accident, and they refile, but in North Carolina, which, as you know, has a 3-year SOL. Okay, I guess some of you guys aren't going to participate in the poll question. That's fine. It's basically voluntary. You'll still get your credits. Okay, everyone says, is this case barred in North Carolina? And all those who responded said it was not barred. So let's see what the court says. The plaintiff, this is the Court of Appeals, is saying the plaintiff presumes without legal authority that North Carolina automatically steps in to apply its laws instead of Tennessee's laws upon refiling the claim in North Carolina. And the defendant presumes also without authority that once plaintiff filed her suit in Tennessee, she would therefore be bound by Tennessee law on this claim, even though she voluntarily dismissed the suit without prejudice and refiled in North Carolina. So the court, in their way, and they often talk this way when people don't present authority, which is fine, because apparently And I also agree with you guys. I thought this was a slam dunk issue, but it turns out it was actually an issue of first impression for the court, which is they acknowledge that's why no one presented authority. Neither brief directly addresses the question of the court as far as this appeal, whether taking a voluntary dismissal without prejudice in one state requires the law of that state. Here specifically, the statute of limitations to control. So are we going to follow Tennessee SOL because that's where the case started, or do we follow North Carolina SOL, even if the state claim is later filed in a different state, which has a longer SOL? Essentially, this is a question of how voluntary dismissal without prejudice operates between states. Good question. So ultimately, the court says that they agree with you and that under either Tennessee or North Carolina law, you are allowed to have voluntary dismissal without prejudice, and the plaintiff is exactly where they were before the case was filed. So the plaintiff is in a position that, so you go back, if you do a VD, you're back before the case was filed, which means you were in a position based on rules of personal jurisdiction and venue, you were allowed to pick because you had this situation where you had Tennessee plaintiffs who had an accident in North Carolina, and therefore the plaintiff always could have picked North Carolina, and therefore they would have been under the North Carolina SOL. There was something that happened in Tennessee that I just want to make sure you're aware of because it felt different than North Carolina. The Tennessee court's order voluntary dismissal placed no restriction upon plaintiffs upon refiling a claim. I thought that was interesting that the court said that because in North Carolina, there would not have been an order, right? Because when you file a voluntary dismissal, it's a notice. Sometimes we get into debates in certain courts about whether we're making notices or motions in situations like this, like in bankruptcy, for example. You have to do a motion to dismiss your own case. But here in North Carolina, I would not have filed a motion to dismiss my case. Therefore, there wouldn't have been an order. So I thought that was something worth just acknowledging. So the next case here that we dealt with was when the default isn't always a defaulted thing to do. So we know that if we're the plaintiff's attorney, one of the things that we learned early on is that we file our lawsuit and we set our calendar. Once we get service, we set it for 30 days and cross our fingers and hope that the other side doesn't answer. And then we'll go in and immediately file a motion for summary judgment or a motion for default judgment, right? That's appropriate. And so for those of you who don't practice in that area, make sure you make a note to do that. Always do that. So here is a little twist, which is how life is. You know, we are comfortable with our understanding of the law, and then we get twist. So plaintiff filed what it hoped was a regular negligence complaint, not a medical malpractice complaint, which is something we'll talk about in a moment, because that's just a big issue by itself. Defendant filed was granted a motion to extend time to answer, and so the defendant was given until March 7th, okay? The defendant then filed a motion to dismiss on March 9th, but served it on March 3rd. So what does that mean? On March 3rd, the defendant actually served the response of pleading, which was a motion to dismiss, but had not filed it. So the deadline to answer was March 7th. So the plaintiff filed this motion for entry of default on March 29th, which is a whole separate weird thing that happened. So we'll kind of ignore that part, but focus on this part. You get a deadline of March the 7th. You mail a copy of the motion to dismiss to the other side on March the 3rd. But you don't get to the courthouse to actually clock it in until March 9th. And for those of you who think, well, that sounds weird, well, that's because you're probably some fancy lawyer in Raleigh or Charlotte who has easy access to the court system. Well, when I first started practicing, a lot of times my cases were 4 hours away. So I practiced up and down the coast of North Carolina, Hyde County. You might have heard of that, Swan Quarter, right at the coast. And so for me to file a document was an all-day activity unless I mailed it. And so, anyway, I'm just telling you that sometimes that's what's happening. If you're wondering why would they not just file the document at the same time? Well, they didn't. So the clerk signed the entry of default. Plaintiff was ultimately sanctioned for this in a later hearing. Defendant moved to dismiss because the case was really medical malpractice. So I have a question that I want you to think about. Is a serving without filing of a responsive pleading sufficient to meet the timing requirement? Because they served by the deadline, but they did not file by the deadline. So what are we saying when the court gives you a deadline on March 7th? Are they saying file it? Are they saying serve it? Or are they saying both? To give you guys a moment to answer that. Give you guys a moment. All right, just wait for you guys to respond. I guess you're in non-responsive mode today. All righty. Okay, so most of you guys are saying you need to only file the response. So let's review what the rule actually says. It actually says that Rule 12A requires only that the defendant serve the response. So it's not filing, it's serving. So it's an interesting quirk in the rule because most of us who have ready access to a courthouse, like the courthouse is down the street, we come and I don't I think once in my career, and I have actually served an unfiled document. I think I did it once. I vaguely remember one time doing this, but I distinctly remember when an attorney served me with an unfiled pleading, and I remember jumping up and down about it because I felt like it wasn't right. Um, and so I think obviously I looked at the rule to see that that was right, but then it made me so uncomfortable. I went to the courthouse to get a copy of the file stamp version just to make sure that they weren't playing some hokey pokey because it was literally, we've all had some strange things that happen to us throughout our careers, but that was the only time an attorney had ever served me an unfiled pleading. And it turns out you can do that. It's just we don't. So I do want you to know that that's what the actual rule says is um, that we don't have to do that. So I thought that was interesting. So anyway, so determining, and by the way, before I move on, the plaintiff's attorney who had actually gotten the motion who had actually filed a motion for entry of default and the clerk entered it, I just want to remind you that the significance is that lack of appreciation for that rule cost that attorney to have to pay sanctions. He had to pay the other attorney's fees that they had to use in objecting to and getting the motion for default entry set aside. So it was a healthy penalty based on a situation where a lot of us, including myself, would have just presumed that the rules said the logical thing, which was you must file and serve by this date, but it doesn't say that. So that way, thankfully, none of you and I would never make that mistake. So the next case dealt with something that comes up a lot, determining if you must meet 9J. So for those of you who don't practice in the area, I'll start by saying, for me, I don't want to meet 9J. And if there's a debate about whether I can meet 9J, I meet 9J or not, and this is about getting a doctor to sign off and saying that this this medical record looks like it's a situation where there is medical malpractice. Okay. Why do I want to avoid that? Well, the main reason I want to avoid that is because it's expensive. Even if it's, I've found doctors who have done a medical review for like a $1,500 flat rate, which is great, but most of them don't. Most of them is $5,000 at least. And in fact, we may be able to get to another cash flow update that we did earlier last year, in which the court admonished an expert because the expert got on the stand and said, instead of reading all the medical records, he read the relevant medical records, which to me is appropriate. I'm paying you $500 an hour. I'd like for you to zero in on what's important. But the court reminded us, the Court of Appeals reminded us that in fact the rules said that the doctor was supposed to have access to all the records, not just the relevant records. So as a side note, one of the things that we come up with here is this idea of getting a legal, we call them legal nurses. I don't know if that's the right term, but that's what I know. The one I use, that she calls herself, is a legal nurse. And so for me, and it doesn't satisfy 9J, let's be clear about that. It basically, in the end of the day, it could actually cost you more money because it doesn't satisfy 9J. But this is what I've done in my practice, and I'll share with you. When facing what I think is a good medical malpractice case, before I hire the doctor who charges $500 an hour to review the records, I hire a experienced legal nurse. In fact, one of the legal nurses that we use is actually a licensed attorney as well, but she has a nursing background. And so in this capacity, she's operating as a nurse. And the nurse reviews the file for a lower rate than the doctor, and the nurse comes back and says, these are the issues that I see that could potentially be medical malpractice. Or the nurse, in one of my cases, came back and provided me with really great information that helped me to appreciate that it wasn't medical malpractice. And so I never did the 9J certification because I knew I wasn't going to get it. I had a very thorough analysis that convinced me and my client that it wasn't medical malpractice. Or what happened more commonly would be the nurse would give me the ammunition and the motivation to decide, yes, I'm now willing to pay the doctor. And now I can, even though the doctor needs to review the entire file, I found that it's extraordinarily helpful to do two things. Number one, I give the doctor a copy of the legal nurse's analysis. And number two, it helps me to have a conversation with the doctor because sometimes they're sort of talking in terms that I don't understand. And it helps me to zero in on the issue that I see. And it just makes it for a better process. So anyway, I want to mention that about 9J and some of the preliminary stuff that some of us have started to do because it can become very burdensome. I knew a colleague who would spend tens of thousands of dollars having a medical record reviewed only to find out that he couldn't get his 9J certification because it wasn't medical malpractice, and this was money out of pocket. And I personally wouldn't be interested in paying that. But it's a process. It's part of the process. The other thing that I want to mention as we're talking about this is another trend that has happened that I think is super duper inappropriate, but it's just something we need to talk about as a profession. I sent a demand letter to someone once, and I hadn't even decided, based on my own research, whether it was a medical malpractice case or not. It might have been what we're calling ordinary negligence. But in any event, I sent out a letter to whatever facility it was, and they responded and said their policy was that they would not engage in negotiations. Mind you, this is well before we're going to file a lawsuit. It was so early in the process. But their response to me, and this was their insurance company, their response to me was to say, our policy is that we don't engage in negotiations unless you have gotten a 9J certification from a doctor. And I kind of thought that's amazing. Like, if I go through that effort, then I might as well file a lawsuit and sue you, because if I literally get a doctor to say this is medical malpractice, then my client is so fired up that why should she want to settle? And that's just something to think about. But anyway, it's just a big conversation to have about this, because what I want to show you in these cases, though, is once you make that determination about whether it's 9J or not, then we got to talk about pleading and how you're going to plead so that you don't basically mess it up, for lack of a better word or phrase. So here, the claims alleging injury as a result of clinical judgment and skill sound in medical malpractice, while cases alleging injury in a medical setting do not necessarily, or do not, but not including medical assessment, offer ordinary negligence. And so this is an important threshold for you to start your case, because some of you may only do personal injury, but then you don't do a personal injury situation that really involves medical malpractice. And so you got to make a decision about which is which, for all of these reasons, cost reasons, whether this is something you're willing to engage in. So all of these things are important, because once you file the case, and I have a case in a moment that I'll show you that literally says this, you don't get to file the case, which to me would be a cool rule to say. You don't get to file the case under ordinary negligence, and then the court determines that it was medical malpractice, and then you come back and do your 9J certification. Honestly, if I get to be in our state legislature, that's a rule change that I think is appropriate. I think that's appropriate. But I'm not making the rules yet. Right now, I'm just explaining what the rules currently are. So right now, you can't go back and change your mind, one, because your case will be dismissed, and it'll be dismissed with prejudice, and so it'll be over. But anyway, so the big chunks that you're going to put your case into, two big chunk categories. Are we dealing with something that related to judgment and skill? Like the doctor should have seen this on the x-ray, you understand? Or the nurse should have known that this wasn't the right medicine to give, or whatever, That's clinical judgment and skill. Or the doctor performed the surgery and didn't do it right. That's clinical judgment and skill. But there are times in which it is regular old negligence, but the tricky part is it happens in a medical setting. So here are the common examples, and I have a case like this right now. My client fell inside of a building because for various reasons. One example could be because the floor was wet and there was no wet floor sign. That's not my case, but you understand the point. Generally speaking, if a client walked into your office and said, I fell in a building because the floor was wet and there was no wet floor sign, you would say, okay, that's a negligence case. It's a slip and fall. I'm all in. Let's go. I need to look at the floor, whatever. The difference is the wrinkle is going to be when your client tells you that this thing happened, but it happened in the hospital. Okay, so, or the nursing home, or the doctor's office, or whatever, some sort of medical setting. So this is how we're going to approach it. We're going to look at the core of what happened and not look at the physical setting in which it happened. And this is how we're going to talk, because of course, just be clear, if you ever file an ordinary negligence action that somehow in the realm of life connects to a medical setting, I can guarantee you with a 99% degree of certainty, the defendant is going to file a motion to dismiss because you didn't meet 9J. I can assure you that is one of the things that happens, okay? So just know that is going to happen. So the question is, how do I walk the, so we're going to have that hearing. How, you have to know that going into this. How do I structure my pleadings and then structure my oral argument to walk the judge through the analysis so that the judge sees this is not 9J? And the way that I'm going to do that, I'm going to plead it very carefully and not mention the medical setting, okay? For example, in my example, and that probably is too easy, so I think I'm gonna give you a better example. I had that slip and fall in the hospital. That's too easy. My real example is my client had back surgery, okay? And she comes back to her room after having back surgery, and the bed is uncomfortable. They move her and they move her and they move her to get to a comfortable bed. Okay. In the end, they put her on this sort of chair, like that I guess it's like a recliner type thing. And she falls out of the chair recliner and hurts her back more. And now she has to have a new surgery that the doctors will agree would not have been necessary but for that fall when she was in the recliner. So the question is, and this happened in a nursing home and like a rehab facility, so that's your medical setting. So the question is this a situation that related to clinical judgment and skill, meaning that they should have known as doctors and nurses that this sleeping environment was inappropriate for someone who just had back surgery? And therefore, you have to meet 9J because because that would have been an appropriate place to sleep, but for the back surgery, and they should have known that, which relates to skill. Okay, that's chunk number one. That gets you into your 9J. Chunk number two, take away the fact that it was a nursing facility, okay? And let's see if we can talk about it and it gets to the exact same place without it being a nursing facility. So, client is laying in a recliner. By definition, there's no ordinary negligence there. Client falls out of the recliner, okay? Do you get to ordinary negligence without adding those additional details? And unfortunately, because I want this to not be 9J, but unfortunately, I hope that you can now see in my example that you can't get to ordinary negligence without including the medical setting and the skills and the judgment. Because outside of the medical setting, all you have is a human being falling out of a recliner, and there was nothing wrong with the recliner. If a person who didn't have back surgery had slept in that recliner, they would not have fallen. And even if they had fallen, it would have been their own fault. So that's contrib. And if they had fallen and it wasn't their fault, then guess what? They would not have required additional back surgery. So you can see that's the way that analysis is going to go. So ultimately, that particular scenario that I'm referring to is 9J because you can't get to ordinary negligence outside of a medical setting. Before we move on from that, I want you to still, again, appreciate my original fact pattern, which was I slipped on the floor because the floor was wet and there was no wet floor sign to warn me and I didn't know the floor was wet. Okay, that happens at Bojangles. Does anybody have a problem seeing the negligence? There's ordinary negligence because there's a standard of care that has been breached. And we all can see floor wet, needed a sign, client didn't know floor was wet, client falls, there's duty to the customer, breach of duty because there was no sign. There is causation because you have The reason she failed was because there was no sign, and then there's damages. Boom. All day long, ordinary negligence. Take that same example, put her in the hospital, the same analysis applies, and you never have to mention the hospital. It could have been Bojangles. Floor wet, no sign, didn't see the water, didn't see a sign. I failed because of that. I'm hurt. That's duty breach, causes and damages all day long. Okay. All right. So in the current case, the decedent died because she drank body wash. The argument is that the staff failed to supervise her, thus allowing her access to the body wash. So this is an unfortunate situation in that case that you had decided a moment ago. The decedent was in the facility, drank the body wash, poisoned her, she died. So give you guys a moment to think, is that medical malpractice or is that ordinary negligence? Give you guys a moment to answer that, please. All righty, let's see what you guys are saying. Looks like most of you guys are saying that it's ordinary negligence. All right, well, let's go to the court's opinion. In a similar case, the court was holding the plaintiff's claim was for ordinary negligence where the nursing home failed to supervise a patient smoking cigarettes. So that's your precedent case that gives you a similar analysis. So, well, let's look. So let me just back up for 1 second. I want you to see that because I need you to compare that to what we're going to talk about. So, precedent case says ordinary negligence where the nursing home failed to supervise a patient smoking cigarettes. Patient wasn't supposed to smoke cigarettes. If they had done their job as far as supervision, then the patient wouldn't have smoked cigarettes. Therefore, it was ordinary negligence because you could have been home or wherever, and if someone has a duty to supervise and they don't supervise, then that's ordinary negligence. Everyone sees that? So now you're thinking, well, yeah, well, that means this particular case is ordinary negligence, which it would be, but for what I want to show you happens next. So this is how the plaintiff pled that case, and this is what I want to talk to you about because this is where we as the plaintiff's bar can do better. The plaintiff filed an amended complaint, which for me makes this worse because that means they thought about this in great detail and someone gave them bad advice or someone who they consulted with. Honestly, what really happens, they consulted with someone about this pleading and it was not right. Should have consulted with me. Plaintiff amended complaint alleged that defendant, among other things, failed to possess that degree of knowledge, training, and experience ordinarily possessed by others practicing the specialty of geriatric medicine in similar communities. Failed to apply the degree of training and experience in the case. Failed to provide and timely interpret information related to them, which was why she Why is she vomiting? And they should have realized that she had drank something, that was poisonous. Failed to timely discover and disclose the cause of the nausea. So if she had done that, then she might have lived. Unfortunately, they didn't, and she passed away. Failed to timely and appropriately interpret the results of the diagnostic studies performed. Okay, let's take a breath here and appreciate what they're doing. Our dear colleague is pleading ordinary negligence. But look at the very beginning of this allegation. Failed to possess the degree of knowledge, training, and experience ordinarily possessed by others practicing the specialty of geriatric medicine. Now, I don't like to Monday morning quarterback, but in all fairness, looking at this right now and understanding that the goal of amending this complaint was to show how it was ordinary negligence and not medical malpractice, do you see the problem? They pled a very clear medical malpractice case, my friends. So the court said, even a cursory reading of these allegations shows that each of these contentions contemplates the use of specific knowledge. They talked about it was a specialty in geriatric medicine. They talked about knowledge and skill. They literally used the words knowledge or skill. They literally said that in assessing and subsequently addressing the decedent's condition. Plaintiff alleges much more than mere failure to supervise. Specifically, plaintiff amended complaint alleges failure to interpret symptoms, discover medical causes, and then diagnose and treat. Far more than simple failure to supervise. So, interestingly, you have a case which actually, based on the precedent, was in fact an ordinary negligence case. It could have been. It could have been a failure to supervise case. So that's what we're facing right now, right? That's what we're dealing with. We are dealing with precedent that gives us failure to supervise ordinary negligence, but you can still squander that away. So for those of you who said these facts raise ordinary negligence, you were right. But that's why, see, the defense bar is going to manipulate this case, all right? I don't want you to let them get away with it. They're going to use this case as an example of failure to supervise being medical malpractice. And you're going to come back and say, no, Your Honor, that is not what this case was about. This case was about pleading. They pled more than ordinary negligence and simple and failure to supervise. So that's how you're going to defend when they file that motion to dismiss your case anyway. So the takeaway here is in ordinary negligence, you can safely allege a failure to supervise. But if you allege more regarding the skills, it will relate to medical malpractice and require 9J certification, right? They want to appreciate that because if we look at it too quickly, the other side is going to use that case against us, and it's not right. Because that's not what the court said at all. So I feel like this actually is a helpful case to us, even though the plaintiff actually lost, but we understand why, and we get to learn and grow from that. So that's what I want you to see, okay? Any thoughts or questions about that? Okay. So in our next case, I call it when the judge wants to give your client more money. Oh yes, it happens. The patient had unnecessary surgery. Everybody agrees the surgery was unnecessary. But then she did not keep her follow-up appointments with her doctor. So the question was about mitigating damages. So remember at the very beginning of this presentation, I told you we were going to come down to some procedural and some technical stuff, right? Imagine A client walks into your office one day, sits down for a consultation, and she says, "My doctor acknowledges that he gave me a surgery that I had to go through a surgery that was actually unnecessary." Now, you don't get a better case than that. And so I'm all in, let's go, because that's the right answer, because that's a slam dunk case. Oh, but then here comes the defense bar. Then they're going to say, well, wait a minute. She had an unnecessary surgery. Okay, we stipulate to that, and we'll even get into a fight about, well, how much of that information gets to go to the jury because we stipulated, which I hate that idea. But we're going to argue the doctor who gave her the unnecessary surgery told her to come back with some follow-ups because we can't undo the fact that we gave you unnecessary surgery, but we can mitigate your damages. And I don't know about you, but if a doctor gave me an unnecessary surgery, I'm not going back to him. I mean, really. But this is what happened in the trial. On the verdict form, the jury found that she had suffered damages in the amount of $512,000, but her damages should be reduced by everything but $1 because her unreasonable failure to avoid or minimize her damages. Accordingly, they awarded her $1. Amazing, right? So some of you, depending on where you practice, and I think I've heard that it's a very localized issue. In other words, there are certain places where juries are anti-plaintiff, and you'll get stuff like this happening. And so they're acknowledging $500,000 of actual damages, and then they're giving her $1. But that's not it. This is a part that is going to get you riled up, hopefully. She did not go back to the doctor who he got on the stand and said, well, she didn't come back to see me for her follow-ups after her unnecessary surgery. Okay. The jury says, oh my God, that's terrible. We can't believe this. Let's give her $1 for her injuries. But guess what? There was actual testimony that she did go to other doctors. The court further found that there was no evidence presented that she unreasonably delayed trying to have her problems diagnosed and corrected, and that given the uncontested evidence that she promptly and persistently made diligent efforts to obtain treatment from other physicians after she terminated a relationship with a doctor, unnecessary surgery guy, no reasonable person could conclude that she failed to exercise reasonable care to mitigate her damages. This is a trial judge. Trial judge here, because usually when we say court, we're talking about the appellate court. The trial judge said no reasonable person would have found this. Now, how does this happen? This is I don't know how this happens. I mean, this is amazing. Like, this lady went through what most of us will agree was horrible, right? She had $500,000 of damages, and she persistently went to doctors. There was testimony, there was evidence of this. She still got $1. In addition, the court found that the amount of the jury's mitigation finding that her conduct was almost entirely her own fault, except $1, it vastly exceeds and is grossly disproportionate to the extent to which, according to her crazy doctor, his experts, her condition could have been ameliorated had she timely sought further follow-up care. Because she did seek follow-up care, just not with him. And apparently she was very diligent about it. As a result, of these and other findings and conclusions, the trial court set aside the jury's verdict and the court's judgment and entered an amended judgment awarding damages of the original amount that the jury had said. The court also entered an order awarding the cost to the plaintiff for $175,000. So this is a trial judge going from a $0 verdict to $5, $6, almost $700,000. So trial court here was this is the Court of Appeals now talking. The trial court was in the best position to determine whether the jury's verdict on mitigation of damages were against the greater weight of the evidence, which is the standard. And so I need to tell the trial judge this if I'm the plaintiff's lawyer, because this is the best place to get relief. So the trial judge heard the testimony and greater weight of the evidence, thinks the jury got it wrong, including whether the jurors were affected by the expert's suggestion that their failure to return specifically to this doctor caused her health to deteriorate, because that's just not appropriate. Accordingly, the Court of Appeals, we affirmed, this is the Supreme Court, we affirmed the Court of Appeals majority conclusion that the trial court did not abuse discretion in setting aside the verdict. So one of the things that are taken away here is plaintiff's lawyers, who are now going to be the trial lawyers, have to have that extra bit of fight. You know, you've got to have that inside of you, because you just went from $500,000 to $1, and then you have to go back and empower that judge, that trial court judge, to say, no, that's wrong. And that's no easy task at all. But you still have to file the motion and make the argument and put it on the record. Even when some of the plaintiff experts did not testify against the doctor who was found liable, the appellate court still upheld the trial judge's order awarding cost. So one of the debates that happened was, you put an expert on the stand or in deposition who actually isn't helpful to you, but you end up winning. Can you still get the cost of that expert? And the court said yes. But the truth of the matter is, and I have some other cases in our earlier case law update this year that talked about this idea that you prepped your expert, you got your expert ready to go, and there are times when your expert just falls apart on the stand, okay? That doesn't mean that, and you ultimately win because you had multiple experts, you know? And so you had this one expert who seemed to be great and kind of sucked in the end. And I had an example of that here, and I'll just briefly mention the example. Earlier last year, the court had an expert on the stand who was supposed to testify about the standard of care. And the case was the situation happened in 2012. And so, of course, lawsuit gets filed 2015, it goes to trial. By the time it gets to trial, it's like 2016, 2017, okay? And on cross-examination, the expert just asked, it was an issue about looking at x-rays and what was the standard applied by some of the hospitals back in 2012. So the doctor on the stand, he says, I don't know what the standard, this mind you again, is 2017, because of course it takes as long. We filed a lawsuit in 2015. It took 2 years to get to trial. So 2017, the doctor was on the stand and he says, I don't know what the standard would have been back in 2012. You know, I would have had to have called hospitals and asked them what their standard operating procedure was in 2012 for reviewing x-rays. The Court of Appeals said that means the doctor was not prepared to testify about the standard of care. The doctor basically in 2017 was able to say, I can tell you that in 2017, this is what is done. I'm not sure that that's what was done 5 years ago. And he really, in his testimony, he made it sound like it was ridiculous. I would have to pick up the phone and call people and ask them to go back. Because if I look at their website, it only refers to what the current policy is. And I don't know if that was the same policy 5 years ago. Court said, well, no, that means you don't know what a standard is, so therefore we don't have proper evidence. And the plaintiff lost that case. But my point in telling you this is the plaintiff's attorney had prepped the witness. Somehow they had missed this whole I know what the standard is because it's like on their websites and stuff like that. But I pulled that information yesterday. And so it's a 2017 standard, not necessarily the 2012 standard. So that little piece was missing, but it ended up being a big thing. So, but the attorney did prep the witness, is my point, right? So ultimately, what I'm saying is just because your witness doesn't turn out to be the greatest witness on the stand, you still have a bill. And if you ultimately win your case, the other side, you still should ask for that money. So here the court says, accordingly, rather than applying the de novo review, the only question here is whether the trial court abused its discretion in its award of cost. The plaintiffs observed the total amount was 175,000 corresponds to the cost itemized by them. They had filed the documents with the court, right? Depositions and whatnot, 89,000. Expert fees incurred were 85,000, and both categories were allowable under the statute. And so the judge awarded that amount. Reasonable and necessary expenses for the stenographer directly related to the taking of depositions, kind of not debatable, like, gee, but I mean, this is fee of cost, and for the cost of depositions and transcripts, those things just add up. Thankfully, I've never seen an $80-some thousand bill for them, but the bills I've seen have been significant, so we appreciate that. Reasonable and necessary fees of experts solely for actual time spent providing testimony at trial, deposition, or other proceedings. We cannot conclude that the trial court abuses discretion in this award, and therefore they affirm as well. So they get the 175,000 because it was itemized, and these are all fees that were allowable in per the statute. But this is the kind of tricky thing that happens. So given that the court has already decided that relief should be afforded to the plaintiff, and given that the trial court's only option was to award a new trial in whole or in part in the event of such determination, the court concludes that the Court of Appeals had ample authority to order implementation of the relief that could be properly afforded to plaintiff on remand. So it gets you something on remand, but they're going to enter that judgment. So it's kind of a little twist there. But in the end, you can see that the judge is empowered, which to me is important to phrase things that way, because judges don't want to be overturned on appeal. And I found that showing the judge that you can do something is a very effective strategy. That's the first thing that I need a judge to know, that you can overturn this jury's verdict. You can, and it's not going to be overturned on appeal. I'm not going to embarrass you by going the one day when they appeal, and then the Court of Appeal says you are wrong. That's not going to happen for you. The Court of Appeal supports your discretion in this situation, and that to me has been one of the best ways to get the judge to rule in my favor. So just as a strategy point. All right, so in our next case, plaintiff had a 2000 MRI in the year 2000. Then the plaintiff came back in 2005 for another MRI. The doctor recommended surgery but did not consider the 2005 MRI. He only looked at the 2000 MRI. And of course, you can imagine if you can make the causation point quite simply, if he had looked at a 2005 MRI, then the doctor may have, and ultimately we know the answer because obviously we're here talking about this, the 2005 MRI would have given different information. So in 2006 and 2008, the plaintiff requested medical documents from the provider and the hospital where they had received the treatments. The records appeared incomplete and irregular, evidencing numerous deletions, additions, omissions, and other alterations. This is the nightmare that we have always been concerned about. I remember clients talking to me about asking me how I was going to strategically get the medical records and make sure they were real versus being altered. And the truth is, I honestly always thought that this was a non-issue. So, but this case unfortunately suggests that it's not a non-issue. This case suggests that this actually does happen. So, all right, so what happens then? We're pre-litigation and we're trying to get the medical records and they're giving us a runaround. That's the issue, right? Believing that they were unable to comply with Rule 9J, which they couldn't without the records, they plan to file a petition to depose the doctor about the surgery and the spinal cord injuries and all that stuff. The petition was denied. There's no case yet. You understand? 5 days later, plaintiff filed orders extending the time to file a complaint and the case, and pursuant to Rule 3, and extending the time to file a medical malpractice complaint, okay, which is the whole procedure that you can go through. So the first complaint also alleged that the doctor negligently breached a direct legal duty to the patient. I'm sorry, what?
Our screen is still on the poll, so we can't see your screen.
Oh, did I not close the poll maybe? Let's see. Let's see, I'm gonna share the poll and I'm gonna take it away. Does that change anything?
No, it's still there.
Okay, hang on, let's play up. Give me a second. Oh my gosh. How about that?
Yes, perfect.
Fantastic. All right. So this is clearly going to be a medical malpractice case, right? We all understand that. It's really, the issue really ends up being about what do I do when I can't get a 9J? And it really shows a flaw in our crucial procedure, but we'll talk about it. And, a direct legal duty to exercise due care and use ordinary care and skill in performing a surgical procedure. That's clearly medical malpractice. And in reviewing the various MRIs, you don't look at the recent MRI, that's clearly about medical judgment. It's not ordinary negligence. Although plaintiffs allege these breaches were negligent based on the doctrine of res ipsa, which sounds right, and the thing speaks for itself, and therefore not subject to Rule 9J. So they're trying, I get it. They couldn't, this is This is the plight of the plaintiff's bar. I can't get a 9J certification because I can't get the records. I've got to file a lawsuit. What do I do? That's the question, right? So what appears to be quite obviously medical malpractice issue, they're doing their best to articulate it as it's not, but not because it's an accident, because, I couldn't get it. So anyway, that allegation squarely conflicts with the long-established authority, the court says, and so the court's not buying it, basically. Precedent case holding that a negligence claim based on a procedure that requires specialized knowledge, labor, or skill is necessarily beyond the scope of ordinary negligence. So I'm not beating up on this attorney because I understand the issue, but that's not the right approach. Can you allege that a complaint is not medical mal, but if that assertion is challenged after filing, then get a 120-day extension to get your medical mal? That's the question that I'm raising, because that's what they're trying to do. I don't think this is the right poll question. I'm trying to see it. Well, let's skip that poll question. We'll just get to the answer, okay? A plaintiff cannot file a medical malpractice complaint without a 9J certification on the basis that no certification is required, and when challenged on that omission, seek subsequent 9J review through a 120-day extension as a curative measure. You can't do it. Mischaracterizing medical malpractice case is, as one sounding as ordinary negligence, does not change the rule of law, the court said. The problem that I have is, if I was presented with this same scenario, what in the world was I supposed to do? And that's the question that I pose to you. So at this point in my life, I get to sit back and analyze these things, but I get to write an article actually that I get to complain about this rule and hope that my state legislatures will read it and consider changing the rule. But here's where we are. I'm telling you from precedent cases that the doctor who does your 9J certification has to have access to all the medical records. Now, this is the thing that's frustrating, and it's not just this area of law, but it's one of those things. We don't have our wonderful powers like subpoena power or discovery power until we file a lawsuit. So I want us to think for a moment before we conclude here about what is the solution, because we know it's not the solution because this case just got lost. So you have to have the doctor to read everything, right? Or at least have access to it, so therefore he can say he has the whole medical record file. But if you write them a letter, yes, you have a statute that says you have to provide me with medical records. But what's your penalty if they don't give it to you? Or this nightmare in which they're actually deleting stuff out of the medical records, which is crazy and completely unethical. So you can subpoena it. If you filed a lawsuit, the attorney even tried to do a pre-filing deposition. So he filed this very clever, quite frankly, petition to get to depose the doctor before the lawsuit was filed, and the court said no, you can't depose a doctor before the lawsuit is filed. Crazy. And so, really good idea, though. Honestly, it was a good idea. It was a good effort. I don't think this attorney did anything wrong, and I don't think his client can fault him for losing. It's easier for us to say, obviously, our client's still gonna be mad. But again, appreciating where we are in this situation. The doctor has to look at all the records. You can't get them. So what he tried to do was file the complaint. You can file basically this extension and that basically draft up your complaint, file this extension, and the court's going to give you, sometimes they give you more, but they'll give you 120 days to get certification, but that's basically extending your statute of limitations. That's kind of what's happening. Like you're running up against an SOL, but you can't pretend like the case is not medical malpractice to get in the game. You just can't. So, any thoughts? Let's see if you guys have any comments or thoughts about that. Anyone have any thoughts to share? I know some of you guys are experienced practitioners here. If you have anything that you could share with us that would be helpful, we will be happy to take that now. Okay. Anybody have a thought about what you would do in this process other than have the law changed? I'm seeing some people saying yes, change the law. So it's a difficult thing to be a part of because some of this is sort of, while this 9J concept is not new, but is now is being used more so now like a weapon. And so we need to think about that. I think that I implore you to use legal nurses to help you get started, especially for those of us like myself who don't have any sort of a medical background whatsoever. And when I listen to my clients' stories about what happened, of course it sounds horrible. Most of the time, someone's hurt and someone's dying. So yes, as a human being, I feel sympathy to that, and the person is explaining it with such passion that I get fired up too. At the same time, I'm now staring down the barrel of an $80,000 bill from some doctors and some stenographers who did depositions for me, only to find out that it was a medical malpractice. And so that's not a formula for an effective practice. So, but anyway, it's food for thought. Those are things that our Court of Appeals has been wrestling with. So hopefully we'll get more guidance when you come back for our 2020 update on what the court's wrestling with this year. Any thoughts or questions as we wrap up? This is now our time for comments and questions. All right, hearing none, I will say thank you for participating. This is our first course of the year. We look forward to helping you work through your legal education process for the rest of the year. Thank you so much and have a wonderful, wonderful day.